Mr. Weber, you're charged with two cases. You're charged with assault of a family member. You're also charged with terroristic threat of a family or a household member. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Just so you know, I appointed you a lawyer yesterday. Your lawyer is here with you now. He is on Zoom. We're going to do probable cause now.
Yes, Judge.
Judge, I don't know if you remember, we did probable cause yesterday. You found probable cause, unless you want to revisit it.
The judge is reopening probable cause? That's rare. Either this case is a legal mess, or the judge suspects something's off. Notice how the defendant's lawyer hesitates? That's the sound of someone bracing for disaster.
I do, because I don't remember anything about it, and I want to be able to hear it with him so that we're all on the same page. Just real quick, if you don't mind.
No.
Okay.
Yes, Judge.
Please.
On March 4th, 2025, in Harris County, Texas, officers were dispatched to an assault in progress call. The officer met with the complainant and the defendant, who both stated that an assault did not occur. The officer then met with a witness who stated that he observed the defendant swing at the complainant 3 to 4 times. The officer spoke with a second witness who stated that the defendant opened the passenger door and punched the complainant 5 times. And when the complainant got out of the car, observed the defendant strike the first witness in the torso and shoulders. The officer then spoke with a third witness who stated that he saw the defendant strike the complainant 3 to 4 times with a closed fist and heard the defendant state he would fuck you up to the complainant.
Mr. Weber, I don't want you to have any contact with this person. Do you understand me?
And Your Honor, if I may, after having contact with the complainant and Sebastian for me as well, we would be okay with no threatening and harassing.
No.
Yes, Judge.
No. I don't want you to have any contact with this person. And I want you to understand now that I'm going to protect every person in my county, regardless of who they are, what color they are, they're a small farm animal. Do you understand? Don't have contact with this person. If I find that you violate these conditions, if I find that you become a danger to my city, if I find that you pick up a new case, I'm going to revoke these bonds and I will make them high. Do you understand?
Judge, if I may.
Please.
Judge, the CW was the one that came into court yesterday. She's a clerk for the Harris County district. She's a clerk there in Harris County.
Say it again.
She's a clerk there in Harris County.
The complaining witness is a clerk here in Harris County?
Yes, Judge.
Okay.
She's the one that gave us those affidavits yesterday that you showed me.
I understand, but I've got, go ahead. Go ahead.
She did not have any visible injuries. She states to me and to the district attorney that they were fighting over the keys and that it was just that it was mutual and that no injury occurred. She did not have any bruising again. She told that to the officer when she was arrested. Oh, I'm sorry, when my client was arrested. There were no visible injuries, nothing that would corroborate what the witnesses are saying.
There are 3 different independent, unrelated witnesses who see first 4 to 5 punches in the head, and then as he allegedly takes her out of the car, these same witnesses see 3 to 4 punches in the stomach as well.
Again, Judge, if that
The defense is pushing hard on no visible injuries, but 3 witnesses saw punches thrown. In court, testimony often trumps bruises, especially when multiple people swear. Under oath. This guy's walking a tightrope.
that were the case, we'd have some injury, Judge. We don't have any injuries that are noted by the police in the report or by the CW when I saw her yesterday or the prosecutor when he spoke to her yesterday, Judge.
Judge, just to confirm, yes, that's what the complaint told us as well. The same thing. There were no visible injuries, no bruising. And that's why I'm asking you, we'd be fine with no threatening harassment.
Come up, ma'am. I want to make sure that every single person here is protected, you know, and 99.9% of the time, I always like to follow what the complaining witness is, meaning you, what your wishes are. Because, I really take that into account. I have to be honest that from what the witness's statements say, it sounds really, really just aggravating and just, I don't want you to say anything. And so when I see something of this nature, it really takes me back. And that's why, there's a method to my madness and why I do what I do, and to protect you, because I don't want something to happen to you. That's because you're the person I care about. What would you like?
I have those affidavits in my prosecution for a reason. I never called the police. I don't know what they saw.
I don't want to talk about the case. I just want to know do you want to have contact with this person?
Yes. We deal with a lot of things together. He didn't hurt me, so I want to.
There is an order for protection that is in place now. I don't give a rat's behind what is going on. I don't care what stressors you have in your life. But if I find that you put hands on anyone, I'm going to put my hands all over your bonds and I'm going to rip it. Do you understand? I don't care what is going on.
This judge isn't playing. I'll put my hands all over your bond is legendary, and a clear warning: one wrong move, and this defendant's freedom is gone. The courtroom just turned into a high-stakes game of F around and find out.
Bonds and I'm going to rip it. Do you understand? I don't care what is going on in your life. You put hands. It's really not going to go well. Number one. Number two, the court order that I have now, the order for protection, says that you're not to have any threatening or harassing contact with the complaining witness. I don't care what you think is threatening or harassing. It's what she perceives. So can conduct in and of itself violate this thing? If I go like this, is that threatening or harassing? It is, and it will land you in jail. Do you understand? I will do what you wish, but if I find anything happens in the future that hands are put, threats are made, I'm going to yank the bonds and that's it. Okay? So if you guys want to do a rip now, I don't know if you've already done it.
We've already,
But okay.
It's fun, Judge.
So do you mind filing no threatening, harassing, no weapons? You're not to be in possession of weapons as well. Do you understand? Okay, take a seat for me while we get everything ready for you, sir. Good morning, Ms. Ford.
Good morning.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed for you, ma'am.
I apologize. What's the last name you're on?
P-O-U-R.
Okay. On March 2nd, 2025, the officer was dispatched to an accident on the 4500 block of Southwest Freeway, and the defendant was passed out in the passenger seat of a tow truck. The officer noticed that her eyes were low, her speech was slurred, and her breath smelled like alcohol. She had also urinated on herself. The defendant stated she had one drink and was coming from a club, and the defendant showed lethargic behavior, and the defendant confirmed that she was the driver and that no one was with her. Standard field sobriety tests were administered: HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant consented to breath, and the results were 0.128 and 0.118.
Where was she driving? What was she doing? All I know is that she's sitting in a passenger seat of a tow truck. How did she get there? What happened? Was there an accident? Who is writing these reports nowadays? I mean,
Yes, Judge. And the statement made statement stating that she confirmed that this was her vehicle and she drove it to the crime scene. The defendant confirmed that she was with only her and no one else was with her. The defendant confirmed that she was on her way home from a club. where she consumed alcohol, and the defendant's vehicle was found stalled on the shoulder of a busy freeway. And the officer wrote that led the affiant to believe that that there was no one else that fled from the scene. And the officer wrote from the affiant's training experience that he believed that the defendant was the driver of the vehicle based on the statements made to him and finding the vehicle.
Did anyone see her drive? Did the tow truck driver see her drive? How long did she drive? When did she drive?
We don't have that information.
So it says that there was, Deputy DuPont was dispatched to a one-car minor accident and the vehicle was leaning on its side and stuck in a muddy ditch. The defendant was passed out in the driver's seat with the key inside the ignition and the engine running. That deputy woke up the defendant.
So someone sees her in the ditch.
Wait, is
I think you might have a different.
That's
Oh,
a
sorry,
different
that was
case,
the
right?
wrong case, Judge.
In this
Sorry,
case,
sorry.
she was passed out in the passenger seat of the tow truck, and there's no other information in regard to her driving besides the statement she made. So there's no one that observed it, Your Honor. And we understand.
Let's do this. I'm gonna appoint your lawyer today so we can have someone take a look at the case for you, okay? Ramona, do you mind appointing someone for Ms. Moore, please? Just do me a favor, just take a seat for me in the jury box, will you, please? Okay, so it's a DWI, Class B. Mr. Pons, please.
Yes, Judge. On March 2nd, 2025, the officer was dispatched to an accident call on the 4500 block of Southwest Freeway. The defendant was passed out in the passenger seat of a tow truck, and the officer noticed that her eyes were low, her speech was slurred, her breath smelled like alcohol, and she had urinated on herself. The defendant stated she had one drink and was coming from a club. The defendant showed lethargic behavior, and the defendant confirmed that she was the driver and that no one was with her. Standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant considered a breath, and the results were 0.128 and 0.118. And
We have her in the passenger seat of a tow truck.
Right, so her statement alone isn't sufficient. That's all they have about her driving.
And Your Honor, in the complete OR, there's further statements that kind of clarify the time period that when this happened. The officer stated that at 7:20 a.m., that's when he was dispatched to the accident call, and he arrived at 7:21. And the defendant stated that she was on scene and she was coming from her residence from a bar called Good Mood that she had arrived at 3 a.m. And the defendant stated she had the one mixed drink only and left Good Mood Lounge at 5 a.m. when she proceeded to head home. And the officer found the vehicle on the right shoulder stalled with the front passenger tire blown out. So the the encounter with the defendant took place 2 hours according after when she left the bar.
But none of that saying, well, go ahead. Calm down, Chief.
So do we have an officer that actually sees her in the car in the ditch?
No, Your Honor, the car is just found in the
Oh,
ditch
she
with the
won.
tire blown out, and the only thing the officers have to put her in the vehicle is her statement saying she drove and when she left the bar.
Well, that's it then. If that's the only thing they have, no PC.
Why?
Judge,
Their statement alone can't be sufficient evidence. They need corroboration.
And the corroboration we have is that when the officers arrived, there was nobody else on the scene. It was a crowded freeway. There was nobody else who could have gone to the accident or left the accident because they were on a highway with traffic and there were no other people around.
One, I don't see that the officer said any of that. Two, that's still not going to corroborate that she was driving.
Why are you saying that the statement, her statement in and of itself is insufficient?
That's a rule. I can give you a case if you want.
Yeah, I do.
Okay, well, give
So-
me time.
Yeah, and I'm willing to, if you want, maybe like we can revisit on Monday,
Okay.
because I want to give you time. I want to,
Waive her appearance for Monday?
yeah, I'm going to put her under conditions though, but yeah,
Understood.
okay. But I'd like to do a deeper dive on the PC and I want to know, is that in and of itself insufficient? And it'll give you more time as well.
I'll reach out to the officer.
Let's reach out Monday and we'll do more, I guess, a formal hearing. Ms. Poor, we will have an additional hearing on Monday to determine whether there's sufficient probable cause to go forward. So you need to stay in contact with Mr. Pons and he will tell you how we went forward on Monday. As it stands now, I'm ordering you not to consume alcohol or illegal drugs while you're on bond in this case. Do you understand? If I find that you consume alcohol or illegal drugs, I'm going to revoke your bond. I will put you in jail. Did you guys run a license, please? And any other prior DWIs?
Your Honor, no prior DWIs, and we're running her license right now.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, you are not allowed to drive. Do you understand? Okay,
Your Honor.
great. So for now, I'm going to have you sign a reset with Ramona. We're going to set it for Monday. You don't have to be here. No. We're going to waive your appearance, but Mr. Pons will let you know how everything transpires on Monday. And then after you sign the reset, I'll have you meet with Fleischer if your bond conditions, and after that, you'll be free to go. Okay? Okay, Mr. Pons. Thanks.
Okay, thanks.
See you Monday.
So she needs to meet for bond conditions.
Yeah, well,
Okay.
she needs to sign the reset, but yeah. Mr. Crump, you are charged with unlawful restraint. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 1st, 2025, at approximately 2:27 p.m., the officer was dispatched to a disturbance call in Harris County, Texas. Upon arrival, the officer met with the complainant, who stated that her child's father caused the disturbance and got her kicked out of the motel. The complainant stated her and the defendant got into an altercation due to the defendant trying to take a child away that they have together, and the complainant not wanting to be together anymore. The complainant was attempting to leave the room when the defendant began sitting against the door, preventing her from leaving. The complainant stated she grabbed the defendant by his hair and started striking him with a closed fist because she was in fear for her safety due to a previous offense report from Harris County Sheriff's Office. The defendant called his brother, and the defendant's brother entered the room and started recording the incident, and the defendant was trying to leave with the child, and the complainant attempted to get him away from the defendant. The complainant was unsuccessful, and the child bumped his head on the door, and the complainant stated she knew the defendant by name, age, and sight. The officer was able to locate the defendant's driver's license and positively identified the defendant. Another call for service came from another location regarding an assault that occurred at the original location. Upon arrival, the officers met with the defendant, who stated he was assaulted by the complainant. The defendant stated they were having a conversation in the restroom of a hotel and that he was standing in the doorway when all of a sudden the complainant became belligerent and started cursing him, telling him to leave. The defendant stated he was punched in the face and suffered a busted lip, and the defendant stated his brother was called to mediate and be a witness. Then the complainant began cursing at the brother. The defendant stated the complainant grabbed the child by one arm and threw him on the bed like a rag doll.
Mr. Crump, I'm going to find that there's probable cause to go forward with the case. Did she ended up getting charged as well?
I do not see a charge for the complainant, Your Honor.
So just don't have any contact with this person. That's all I'm asking you to do. You know, sometimes when you have cancer in life, what do? You cut it out, because if you don't, it kills you. Some people in life can become a cancer to you as well. So that's it. I don't want you to have contact with this person. Do you understand? If I find that you do, I'm going to revoke your bond. I will put you in jail. I'm also ordering you not to be in possession of weapons as well, Mr. Crump.
¿Están claros? ¿O que va a tener que centrar ahí?
You have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer? Okay, I'll have you fill out an application. I'll take a look at it. I'm going to have you sign a reset with Ramona. After that, I'll have you take a seat in the jury box. Do not leave until you sign our bond conditions. Do you understand? Okay, come on. So can you file no contact and no weapons?
Yes, Judge.
Tyler,
A couple of quick things I forgot.
okay,
On the two clients I approached on earlier, I didn't ask you to sign the blood discovery orders. I've had.
I'll put them in. I'll sign everything for you.
Okay, I don't need one to show.
What, is it the standard one, or is it?
Standard?
Okay,
Okay.
so some of the stuff that they've seen already.
We filed it. It's in your queue.
This is just a standard blood discovery.
Standard blood
Okay.
discovery
Then I'll
order.
sign it.
You will sign them today?
Yeah, of course.
Okay, thank you.
Absolutely. Guys, can you put it in the queue?
They're both in your queue.
For both clients?
Yes, sir.
Sorry, Judge, one of those was mine, one was David Smith, so if you see my name.
I got it.
If you can sign the other one as well, I appreciate it.
Yeah. Yeah.
Judge, on Jamal Crump, you ordered him to have no contact with the complainant. They share a son together. Is there any way they could have a third party for visitation?
Well, of course, they can always use someone else, but I don't. Come up, Mr. Crump. I know that you're upset that they filed this case. But when I mean no contact, I absolutely mean it. They're going to call this person now to let them know of the bond conditions that have been filed. So if I get wind that you have contact with this person, then we're going to have issues. I get that you have a son and you should have, or a daughter, I don't know what it was, but you should have access because every father should have access to their child. And I want you to have access to your child, but you got to do it the right way. You know, use someone who like James saying, a third party. Don't take it upon yourself to try to do stuff because it's going to go sideways real quick. Maybe if you have parental figures like your mom, your dad, someone that she probably likes, right? If she doesn't like your brother, that's probably not a good person to use to try to get contact with the child. So try to find someone, maybe he can also help you too. Maybe he can help facilitate as well, where she drops off the child at a McDonald's somewhere, and then you come and you get the child for a certain amount of time, and you drop the child back off at a McDonald's. But don't do stuff your own way. Are we good? Okay.
Thank you, Judge.
Yeah. Your iFront, is it Shake?
Yes, sir.
Sir, you're charged with 3 cases. You're charged with terroristic threat of a family or a household member. You were charged with assault of a family member. You were charged with interference with the emergency request for assistance. All 3 of those, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Can I say something or no?
About the case, or do you have a lawyer?
I was attorney, yes.
I'm sorry?
I was attorney and I need to discuss something, sir.
You are an attorney?
No. I need attorney. I need attorney.
I need hair. We'll talk later. Let's do probable cause first. You have the right to remain silent.
Yeah.
Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir. On February 23rd, 2025, in Harris County, Texas, the officers are dispatched to a threat to life call. Upon arrival, the officer met with the complainant, who stated that the defendant is her husband. The complainant stated that the defendant and her got into an argument and that the defendant stated, "I'm not afraid of the police. I will grab that knife and cut your throat." The complainant then stated that the defendant had on November 16th, 2024, assaulted her. The complainant stated that the defendant grabbed her by the top of her dress, causing scratch marks, and punched her in the chest, causing bruising. The complainant stated that she attempted to call 911, but the defendant ended the call.
Sorry, patience.
The terroristic threat was I'm going to grab a knife and cut
your throat, Your Honor.
Okay. Mr. Sheikh, I'm going to find that there's sufficient probable cause to go forward with your case. Do you have the ability to hire a lawyer?
So this also is attorney. Whatever money I have.
I'm not going to listen. You have the right to remain silent. Exercise that right. Anything that you say, they're going to try to use it against you to prove guilt. So what I can have you do is I can have you fill out an application. I will take a look at it to see whether you qualify. We don't give appointed lawyers like it's candy on Halloween. You have to qualify. And if you do, then I'll take a look. But I need you to fill out everything. As it stands now, I am ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. You are not to go within 200 feet of where this person lives or where this person works. Do you understand?
Jamal Crump?
Do you see whether a order for protection has been entered in this case? Guys, let me see.
And Judge, the DVD prosecutor is on the phone.
Oh.
There he is.
That's
Yes, Judge. I was able to make contact with her. I'm not sure what the discussions were beforehand, but we're going to be asking for no contact to keep whatever the residency restriction is in place right now.
She does not want to have contact with her. Okay.
And I don't see a protective order in place.
On the AFM,
Is there one in the AFM?
Yeah.
But I'm going to also do one on the
Terroristic
terroristic threat.
Yes, Judge.
I want you to understand something and take me seriously when I say this, that when I mean no contact, I absolutely mean no contact. I don't care what's going on in your life. I don't care that you need clothes. I don't care that there's a child involved. I don't care that you need to go get the car, whatever it may be. No means no. And if you violate these court orders, the state can and probably will file a violation of a protective order against you. That is the capital murder of misdemeanors. Do you understand? I am now entering in what's called a magistrate's order of emergency protection on the terroristic threat. This is a court order that identifies the complaining witness as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. Do you understand? This is what I'm saying, that if you violate this order, they can file additional charges against you. Now, Deputy Miranda will give you an application. I'll have you fill it out. I will take a look whether you qualify. Anything else you want? Oh,
No, Judge, we'll probably with no contact.
so can you also file the no contact and no weapons so that it outlives the, okay. Do not leave until you sign our additional bond conditions.
Yes.
Okay, please. Whoa. Double team. Hi, Harold. How are
Well,
you?
they've got two over there too, so.
Friday.
We're approaching on Mickey.
Nikki?
Yes, he's in custody.
Okay.
He's got a fugitive case and then he's got two local cases in this court as well.
So I'm assuming one represents one on the fugitive, you,
Cases.
okay.
Hey, Judge, we're gonna ask if, since he has a parole holder from Louisiana, if you'd be opposed to withdrawing not revoking, but drawing the PR bonds and setting a money bond for him.
Sure.
That way he wouldn't be snatched out.
Credit regardless. If someone's in custody, even if we don't have a hold on them, I always give the credit regardless. I'm happy to do it.
Well, and
But
Judge, the other
We'll
issue
raise it by $1.
is if he goes to Louisiana and bonds out, he has cases here and there and getting back and forth, just setting someone up for failure. because-
So revoke it then?
Well, could you not revoke it, maybe withdraw it? Is there a way to do that without punishing him? Withdraw.
The PR bonds?
We can ask you to reinstate it.
It just, we didn't want a situation where you set up a sire facious.
This certain order from Sylvia Cherry, and last time we tried doing that, it was weird. If we ended up bond revoking it later on because it never went through, which is.
I don't know how, theoretically, I don't know how you would, because I have to have, so what would happen was I would revoke the GOB.
Yep.
And we'd basically have him sit on $100 bond that he just can't make.
Right, but if things were to change or his local cases were dragging out, we could come back and ask you to reinstate the PR bond. Because it's not a true violation, we're just doing it to keep him here to resolve his cases.
Sure.
And can you revoke it?
But like I said, I'll give you the credit regardless. If you want to leave it now as is, he's in custody, I'll give you the credit regardless, or
Well, he signed the waiver and it's Louisiana, so they're gonna come get him.
Can you, if you revoke those, Judge, can you do it in a way that we don't initiate the sire facious to go after him for the bond amount?
they wouldn't. They won't. I haven't seen it in years.
I see them all filed, everybody's cases.
I haven't signed one in 5 years, 5.5 years. I don't even see them filed like they used to, number one. Number two, if I revoke the bond and it puts a hold on so we better not do it, because if I revoke the bonds, it puts a hold on Louisiana.
Well, that's what we want, Judge, so he can resolve the cases here. Because if he goes
Then
to,
I have to revoke the bond,
And then-
because if you want to resolve these cases here first, I have to revoke the bond, because Louisiana is going to come and get him if there's no holds.
You know what, and he's here because he's arrested, that's right, because
Yeah.
as long as you're rearrested within 6 months, then extinguishes the,
So if you guys don't want him to get took, I have to revoke the bond.
that's fine.
And I can just raise it by $1. And then once you resolve it, we can reinstate it. And then that way Louisiana can come and get him.
Sure.
Because I'm telling you, Louisiana comes once, twice a week, so he'll probably be gone by Tuesday if I leave it like this. How long's it been on?
The case is here, all of the cases there.
Hmm?
If Louisiana comes to get him on Tuesday, which they very well might, he'll have the cases there to deal with, the cases here. And if he's going back and forth, that's just asking
The
to.
problem, the issue is, the other issue is this, is that okay, a lot of times you will say, hey, guys, you got to stay in contact with me, right? And then they don't. We end up revoking the bond here because he's in custody over there and he can't get a hold of you, right? So it's a complete mess. So you're really much better off resolving these cases now so that when he goes back to Louisiana, there's nothing here.
Right.
Because invariably what always happens is we end up putting a hold here and then this reverse situation happens over there. Why don't we revoke it? I mean, it's only a trespass and evading, right? What is it, capital case? No,
No, that's fine.
capital trespass?
That'd be fine. And then to just stay here till we work them out. And we're working on how to work it out, which will make sure it's
I
not
mean,
gonna hurt.
I'm not sure. It's not going to take forever, right?
No, I would hope not, but I'm sorry, I couldn't.
Do you have an offer on these cases from this
We
meeting?
don't, it just came in yesterday,
Right.
but I
I know.
can do my best to.
Reasonable with
Yeah,
them too. so.
Our only hesitation is that she has to put on an offer before we have a accurate summary of what's going on, but it looks like the videos did come in, so I'll take a look, see if we can get something on
Can
today.
you go ahead and share it to them so they can get access to it? Okay. So, so 101? Is that okay?
That's fine.
Okay, so do you mind? Okay, and then just let me know once you get, I'll go however you want to go. Just let me know.
Okay.
Yeah, okay. Thanks, guys. Sure.
Thanks, Council.
Judge, next is there on page 16.
Okay, coming up.
You're back.
Good morning, Mr. Ma'am, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. Officers were dispatched to Fairmont Parkway in Harris County, Texas, and the defendant was arguing with her husband in the parking lot and got into the car and drove off, nearly hitting him and causing him to fall to the ground. Witnesses called the police and officers found the defendant in her vehicle near the exit with the car in drive. The defendant ignored the officer's request to turn the car off, and officers noted slurred speech, red eyes, and unsteady balance, in addition to an odor of an alcoholic beverage. Standard field sobriety tests were conducted, HGN 4 out of 6, and the defendant refused the remainder of tests and was transported to JPC. The DIC was read and the defendant refused. A blood warrant was signed and executed. During an inventory of the vehicle, the officer located 2 stemless wine glasses. The glasses contained a small amount of a red liquid smelling of an alcoholic beverage and showed recent signs of consumption. The defendant's purse was located in the front passenger seat and was stained with the red liquid matching the hue of the liquid in the glasses, still wet and smelled of a fruity alcoholic beverage.
Mr. I'm going to find that there's sufficient probable cause to go forward with the case. I am now ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I am now also taking away your privilege to drive. You are not allowed to drive. Do you understand? If
Yes,
I
sir.
find that you do, I will revoke your bond, put you in jail, and I'm going to make it high. You will be signing an affidavit with me today, promising me you're not going to drive. It doesn't matter what you do. Do you understand? Not only that, I'm now placing a restriction on your license that you are not allowed to drive any vehicle that is not equipped with an ignition interlock. I send this order to DPS so that every single officer in this state knows you get pulled over, they'll look you up. They'll see that you need an interlock in your car. And if you're caught driving one that doesn't have one, they will take you to jail. Can you run our NCIC, please?
Yes, Judge. So she only has the one prior from 2000 at a Port 5 DWI, no other prior DWI.
Okay. Do you have the ability to hire a lawyer or would you like to apply
I
for?
would like to apply for a court appointed.
Okay. Deputy Miranda's going to give you an application for an appointed lawyer. I'll have you fill it out and I'll take a look to see whether you qualify. I'm going to have you come up here, swear to us that you're not going to drive. I will get you to Ramona where you will sign a reset. You will get with Fleischer for your bond conditions. I don't know if you have a problem with alcohol or drugs. If you do, now is the time for you to address it. Because if I see it becomes a problem, I will address it for you. And I promise you're not going to like the way that I do it. Do you understand? Okay, come on. I see that you have a lawyer. I don't know where they are, but we need to get cooking. So, okay. So, Mr. Mallard, you're charged with 2 cases. You're charged with driving while intoxicated, second offense. You're also charged with resisting arrest. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 1st, 2025, at approximately 11:08 p.m., the officer was dispatched to a 911 call regarding a vehicle stopped on the road with the male in the driver's seat passed out on North 8th Street in Harris County, Texas. The officer observed the defendant's vehicle stopped on the road facing the wrong side, forcing multiple vehicles to drive around the defendant's vehicle. The officer observed the defendant's vehicle's engine on, with the defendant sitting in the driver's seat, appearing to be sleeping or passed out. The vehicle was in drive with the defendant's foot on the brake. The officer observed an open container of Bacardi rum, 750 milliliter bottle, approximately 10% full, sitting in the front right passenger seat, and the officer attempted several times to wake the defendant unsuccessfully, which led to the officer being forced to break the defendant's front right window to get into the motor vehicle due to the doors being locked. The officer placed the vehicle into park and the defendant was asked to step out, who immediately fell to the ground. The officer observed slurred speech, red bloodshot eyes, a strong odor of an alcoholic beverage, and poor balance. The defendant refused any standard field sobriety test, and the defendant advised he had not consumed any alcoholic beverages, wished to speak to his lawyer, and was loudly repeating no consent to all questions. The defendant was read the DIC and refused breath. A blood search warrant was signed and executed. The defendant was transported to HCA Southeast ER to obtain blood, and the defendant refused to exit the officer's motor vehicle, even when the officer asked multiple times. The officer had to physically guide the defendant out of the vehicle, and the defendant stopped walking while walking to the ER with the officer and advised he wanted to go to the Veterans Hospital. The officer advised the defendant he had a search warrant, and the defendant refused to move. The officer grasped the defendant's upper arm and advised the defendant again of the search warrant, and the defendant refused to move. The officer advised the defendant that if he had to pull him inside, he was facing additional charges. The defendant again refused to move. The defendant advised he wanted to go to the VA hospital, and the defendant started pulling away in the direction away from the entrance to the hospital. The officer attempted to pull the defendant to the entrance, and the defendant continued to pull away. The defendant went dead weight and laid down on the ground outside and refused to move while screaming at the top of his lungs, "Someone help me." The officer was assisted by hospital security in placing the defendant in a wheelchair, allowing transport into the hospital, and the defendant's blood was only able to be drawn with assistance of 3 officers holding the defendant down.
My goodness. Can you run his NCIC? Does he also have a felony DWI with a child as well?
It was reduced to a DWI just above a 0.15.
If you have a problem with alcohol, you better address it, Mr. Mallard. Because if you don't, I'm going to do it for you. I don't want you out in the middle of the night, and I'm now giving you a curfew. You are not allowed out past 9 p.m. to 6 a.m., and I'm going to put a monitor on your ankle so I know that you're not out in the middle of the night. On your other ankle, I'm going to put a scram monitor so I know that you're not consuming alcohol. Likewise, I don't want you to drive. I am now taking away your privilege to drive as well. You're not allowed to drive. Do you understand?
Judge 96?
Yeah.
Raise your hand. Raise your hand.
Heed this warning. If I find that you drive, I can have a contempt hearing. Every single time that you drive, it's an offense in and of itself, punishable by up to 6 months in jail and a $500 fine. Do you understand? I don't care what the justification is. Jesus comes, needs a ride to church. I don't care. Do not drive. I am also now placing a restriction on your license that you.
Excellent. That's all. Cool. I couldn't see them.
I am now placing an additional restriction on your license as well, that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle, number one, we're going to have issues with this. Number two, I'm sending now notice to DPS in Austin so that they know any vehicle that you drive is supposed to have an interlock in it. So if you're caught driving a vehicle that doesn't have an interlock, they will take you directly to jail. Do you understand? At this time, you're not allowed to drive. So you will get, well, you got the scram, so I'm not going to give you a portable device, but I don't want you drinking at all. This thing is extremely finicky that they're putting on your ankle. So know what you put in your body. Do you understand, Mr. Mallard?
Yes, sir.
If I find that you consume alcohol, anything that has alcohol in it, cakes, candies, foods, gums, energy drinks, hair dye, I've heard it all. If I find that you're consuming, it's really not going to go well. So I'm going to have you come up here, swear to this. After that, I'm going to get you to Ramona, where we will have you sign a reset. I will have you get with Felicia for your bond conditions, and then we'll have you take a seat while we wait for your guys to get here. Come on. Great. Okay. Thank you, Smash.
Do you want to correct the MOA that's already filed for the AFN?
What do you mean, correct?
There's a MOA that's already signed that
I want
includes contacts. Like, yeah, includes contact, just not a
I think the new one I put in the specific good cause request for contact.
You put it in the new one.
Okay.
So I guess you could write, if you want to print it out, I'll write no contact in the old name too. So just, it's, you print it out. Let me write it in.
Okay.
Good morning, Ms. Rice.
Good morning.
Ma'am, you're charged with failure to identify oneself while being a fugitive from justice. That makes it a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 24 days in jail with credit for the 8 days that you've done. You need to understand there's a couple very serious points now. Number one, this is going to go on your record. It will be there forever. From now on, you're facing a minimum of 90 days in jail for any new cases that you pick up. The other thing that you also need to understand is that you're on parole. It's very possible that because you're on parole, by pleading guilty to this, it may result in further confinement. I don't know for sure. They may send you to ISF, but they really could send you back to prison because of this.
Yes, sir.
Knowing this, do you still want to do this?
Yeah.
You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off.
Yes, sir.
And how do you plead to the offense, ma'am?
Yeah.
I'll find you guilty, send you to the agreement. Good luck to you. Thank you, Mr. Bonds. Good morning, sir.
Good morning.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 28th, 2025, the officer was dispatched to a crash, and Houston Fire Department was transporting the complainant to the hospital. The officer made contact with the defendant, the driver of the vehicle, and asked for insurance. The officer observed a long neck beer bottle fall out of the defendant's vehicle, and the officer observed an odor of an alcoholic beverage, and the defendant stated he had 1 glass of champagne. Standard field sobriety tests were administered, HGN 4 out of 6, walk and turn 3 out of 8, 1 leg stand 1 out of 4. The defendant consented to a breath sample, and the results were 0.143 and 0.135.
Are you saying that he has alcohol in the car while he's driving?
Sure, they just found the bottle on the driver's side. There's no indication of being cold to the touch or anything like that.
Driver's side where?
Of the vehicle, it just said it fell out of the driver's side. When the full DIMS just says they observed a long neck beer bottle fall out of his vehicle on the driver's side. And that's the only thing that it mentions.
Can you run his license, run him, see if he has any prior DWIs,
Yes, yes.
and then his license?
Your Honor, he has no priors and his license is eligible.
Mr. Nwobodo, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. Do you understand? You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you don't have car insurance, likewise, you're not allowed to drive. We are going to reset your case to give you time to hire a lawyer. So I will have you go to Ramona, sign a reset. After that, you'll get with Fleischer for your bond conditions, and after that, you'll be free to go. When you come back, please have a lawyer, sir. You are Mr. Samuels.
Yes, sir.
Sir, you're charged with failure to identify oneself to a peace officer while being a fugitive from justice. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 28, 2025, the officer was dispatched to a suspicious person call on Montgomery Road in Harris County, Texas. The officer arrived on scene and was informed by the caller that there was a male at the above location that had a warrant and that he was sitting on the steps in front of the apartment. When the officer arrived, he did not observe a male on the steps, so he knocked on an apartment and the defendant answered the door. The officer told him he received a call at the location and asked him to identify himself. The defendant stated his name was Levante Samuels with a date of birth of December 7th with no year given. The officer had officers on scene run the defendant NCIC, TCIC, and nothing came back. The officer asked the defendant again for his name, and he informed him the same name. An assisting officer on scene informed him that the defendant was the wanted person, so the officer detained the defendant. The officer placed the defendant in handcuffs and thoroughly searched him before placing him in the back of the patrol vehicle and was shown the defendant's mugshot and asked the defendant again if he would tell me his correct name, and he proceeded to tell the officer that I already got it. So I asked for a unit with a mobile AFIS, and the officer used the mobile AFIS and was waiting on the defendant, who then stated his name was Bobby Samuels. The officer then had dispatch confirm the warrant, and the defendant stated that he had told him the wrong name because he knew he had a warrant. The warrant was confirmed, and the officer took the defendant into custody.
So you had an open, felony warrant?
I'm trying to find what it was. It was an AFM warrant, an assault family member. I'm trying to see where it's.
It's a felony warrant.
It's a felony warrant, Your Honor.
Mr. Samuels, I'm going to find that there's probable cause to go forward with the case. I'm not putting any conditions on your bond. Just be careful. Don't pick up any new cases. I'm going to protect my community. If I find that you pick up a new case, I'm going to put you in jail. Do you understand? No more PR bonds. Do you have the ability to hire lawyers, sir?
Yes, sir.
Okay, I'll have you fill out an application. I'll have Deputy Miranda give you one. I'll take a look. I'll have you sign a receipt with Ramona. We'll have you fill out the application. I'll take a look, see whether you qualify.